Good afternoon, Your Honors. My name is Lee McVeigh of the Kingsport Bar. I represent the three appellants in this case: Alice Williford, Ken Williford, and LaDonna Street Board Wine. I'd like to reserve 5 minutes for rebuttal if I could.
5 minutes, that'll be fine.
Your Honors, this is a case about debt owed and piercing the corporate veil. I represent, as I mentioned, three individual defendants from the court below: Alice Williford, Ken Williford, and LaDonna Street Board Wine. I know both Mr. Santori and I have given brief recitations of the facts in our briefs. I'll briefly go over those for the court. SPSGNVL, the plaintiff appellee in this case, entered into a contract with AAA Anodizing and Metal Finishing, which for the purposes of this case I'll call the original AAA. That contract was entered into back in January of 2010. It was, at that point, Alice Williford was the sole shareholder of the original AAA, and Ken Williford was a general manager of the original AAA. For about 3 years, that contract went as planned. Original AAA would pay for the services that the plaintiff appellee provided. At a certain point, the original AAA stopped paying on the contract, and the plaintiff appellee sent a letter to the original AAA for payment. In October of 2013, a company was formed called AAA Custom Anodizing and Metal Finishing. They entered into an asset purchase agreement, which is Exhibit C on the agreed statement of evidence from the court below. In that asset purchase agreement, AAA Custom Anodizing purchased some assets, the assets of the original AAA for $500. None of the stockholders or shareholders of AAA Custom are identical to the only shareholder of the original AAA, which was Miss Williford. The court below found liability, and so what's happened is the plaintiff appellee has sued on that contract. The court below found all defendants liable. So the court found the original AAA liable, Custom AAA liable, Mr. Williford, Miss Williford, and Miss Board Wine. What I'm going to do is go briefly through the liability and the mistakes that the court below made in finding liability for the three appellants. I'll start with Ken Williford. Mr. Williford, there's no question, was never a shareholder of any of the corporations that were at issue in the case. Mr. Williford signed the contract with the plaintiff appellee, but he signed it in a capacity as the general manager of the original AAA. He never signed a personal guarantee, was never assigned any shares of any corporation, and frankly, I'm still at a loss as to how Mr. Williford was found liable on a contract for a corporation he was not involved in and never was involved in. The court doesn't undergo an analysis, and I'll talk about this with Alice Williford as well. The court does not undergo an analysis of piercing the corporate veil of the original AAA. It doesn't go into an analysis of how Mr. Williford could possibly be liable for this debt. And so, as it relates to Mr. Williford, I believe the case should be remanded and dismissed, as there's no theory of liability that could hold Mr. Williford liable on these debts. Now, as it pertains to Alice Williford, she, as I mentioned, is the sole shareholder of the original AAA. And I should say there's no question that the original AAA, this is a valid contract between the plaintiff appellee and the original AAA. Miss Williford is a sole shareholder of the original AAA. She did not sign the contract at all. There was no personal guarantee to the plaintiff appellee. And so the only way that Miss Williford could be found liable is by piercing the corporate veil of the original AAA. And frankly, that analysis is just not present in the findings of fact and conclusions of law from the court below. There is, and I will get into that, it's paragraph 7 of the conclusions of law, and I will get into that analysis that the court undertakes. But as it pertains to Miss Williford, no analysis was undertaken to pierce the corporate veil or give any reasoning or theory as to how Miss Williford could be liable for the debts of the original AAA. I'll speak now to LaDonna Street Board Wine. So Miss Board Wine is a shareholder of AAA Custom, which is the second corporation that purchased the assets of the original AAA. In order to talk about the liability of Ms. Boardwine, you have to talk about the liability of AAA Custom. Because if AAA Custom is not liable for this debt, then Ms. Boardwine cannot be liable for the debt. And in that paragraph 7 of the conclusions of law, the court does appear to try and undertake an analysis of the factors in Rogers that courts are to look at when they pierce the corporate veil. The issue with that analysis and the way that that is undertaken is unclear as to how the court and to which parties the court applied that analysis to. There appears to be on the fourth and fifth bullet point in paragraph 7, the court says that AAA Custom used the same office and business location as AAA. Obviously, that's not an analysis of Ms. Boardwine's relationship to AAA Custom. It's an analysis between AAA Custom and the original AAA. But in order to find liability for AAA Custom, the court would not be piercing the corporate veil of the original AAA. The court would have to find some sort of privity of contract or some sort of other agreement that would hold AAA Custom liable for this debt. There are, and I think it's important to note that there is a written agreement, a written document. The only evidence of an agreement between original AAA and AAA Custom is the asset purchase agreement.
Well, I mean, did the trial court find that what that was an attempt basically to fraudulently transfer the assets and leave the liabilities?
Your Honor, if the court found that, it didn't say that. And so there is...
Did he find that corporations here was used as a personal conduit or shell corporations in an attempt to transfer the personal liabilities of the Wilford?
The court did say that, but the problem is Ms. Williford was never a shareholder of AAA Custom, and that's part of what the confusion is in these conclusions of law, is that the court says that, but then doesn't provide supporting facts behind that.
Was she the sole shareholder of the second corporation? The second.
And it's confusing, I understand, yes, because of the different alphabets, but she was...
I guess of AA Custom.
She was not, Your Honor. There's no question.
Who was the shareholder?
Well, there were multiple shareholders. The only one that's present in this case is Ms. Boardwine. But Ms. Williford was never a shareholder in AAA Custom and was never involved. She was, after the asset purchase agreement, she was, for lack of a better term, out. She was not a shareholder of AAA Custom. And so, to continue with AAA Custom and the liability, it is unclear, given the facts presented and the conclusion that the court reaches, how the court finds liability for AAA Custom. There are some facts that the court cites, and there's, for instance, fact number 27 says the liabilities, supposedly all of them, but not plaintiffs, of AAA, which is the original AAA, were transferred to AAA Custom. In order for the court to reach that conclusion or find that fact, the court has to indulge in the parole evidence rule. There's a document, a four corners document that says AAA Custom is only purchasing the assets of the original AAA. The court has to rely on some facts. I would submit that fact number 27 is really a conclusion of law that doesn't have any facts behind it to support it. And so what I would say is there's no privity of contract between the original AAA and AAA Custom. Therefore, AAA Custom cannot and should not be liable for the debt. And if AAA Custom is not liable for the debt, Ms. Boardwine, a shareholder, one of several shareholders, by the way, of AAA Custom, cannot be liable for the debt. As I mentioned before, and my time is short, and I may catch this in rebuttal, even if the court were to find that AAA Custom was liable, The court did not undergo an in-depth analysis of how Ms. Boardwine, how it was going to pierce the corporate veil of AAA Custom. As I noted, many of these factors that it used and states from Rogers are factors between the original AAA and AAA Custom and not Ms. Boardwine. Thank you.
Thank you, counsel. You have your time for rebuttal. We'll hear from the AAA.
Judge McClarty, Judge Sweeney, Judge Davis. First of all, Judge Davis and Judge McClarty, I feel like, who was that, Bill Murray in Groundhog Day. I was before you within the last 30 days, and I'm back before you now, okay? Frank Santori, or Francis X. Santori, Jr. from the Greene County Bar. I represent the plaintiff appellee in this case, SPSGNVL, Inc., which does business as Staff Pro. I'm not going to belabor the facts of this case. I will say some things first in respectful rebuttal to my good friend and colleague, Mr. McVeigh. First of all, Mr. McVeigh had said something about the fact that there was a document, which there was, that says that all the assets of the original AAA were transferred to new AAA, but not the liabilities. Well, the court basically in its findings of fact, sitting without a jury, and I might add without a transcript of the evidence, were clear, succinct, and cogent. 50 some odd specific findings of fact. One of the findings of fact that it found was that with regard to Ms. Boardwine, that the only paid-in capital that Ms. Boardwine offered for this supposed ongoing, or at least attempted to be ongoing concern, an anodizing concern in the Piney Flats Industrial Park in Sullivan County, was payment or repayment of a personal debt. Now, I don't practice corporate law regularly, but I think that I learned in my Corporations 101 that a director doesn't get repayment of a personal debt as consideration, or a shareholder. Usually they buy into stock. Most respectfully, with respect to what Mr. McVeigh said, I think that these findings of fact taken as a whole show that this was an attempt among a lot of people to get rid of a lot of debt that this entity had. The people who took over the subsequent AAA, or the new AAA, basically used that corporation as, and I know that holding companies do this nowadays, they buy corporations and they basically sell them off cheaply, but this is a closely held corporation. What they wanted was the real estate to make a profit, okay? I'm not basically faulting them for that. But again, the thing that I would like to impress most respectfully on this honorable court is this. We have been involved in this case literally for 8 years due to many and various reasons. I would like to think good lawyering by both sides. It's the second longest case I have ever had open, in terms of time open, in a file that I have had in my 38 years. We had a trial where we had findings of fact. We didn't have a contemporaneous transcript for whatever reason. The findings of fact are set forth. The court considered them. The court also considered a Rule 59 motion by Mr. McVeigh. He took, and that's in the record, the court took that very seriously, took it under advisement, and most respectfully, I think in the last hour of the last day that Judge Moody was on the bench, he issued an opinion which was in essence the final order on the Rule 59 motion that Mr. McVeigh had. Now I say, and I say this again most respectfully, the appellants in this case, the 3 appellants, the other appellants didn't appeal, want this court to give them yet more time to have another bite of the apple. As this court knows from the rules of appellate procedure, findings of fact are not going to be set aside unless the preponderance of the evidence holds otherwise. I do not believe, most respectfully, that the preponderance of the evidence would hold otherwise in this case.
Let me ask you,
Yes,
make sure I
sir, Sweeney.
understand. Is there a transcript?
There is no transcript.
Is there a statement of the evidence?
There's a statement of the evidence.
Okay.
And the statement of evidence largely tracks with some exceptions, and Mr. McVeigh and I worked on those. You'll see them when you look at them, Judge Sweeney. But the statement of the evidence largely tracks the findings of fact and the conclusions of law. In other words, it says, and Mr. McVeigh can correct me on rebuttal, the statement of facts are recognized or adopted, whatever, and then there's these 4 or 5 or 6 other facts, which we agreed to. Okay? Does that clear things up?
Yes.
All right, thank you, sir. Now, one thing that's interesting here as to Ms. Boardwine and to Ms. Williford, the missing witness rule, Your Honors, can be used in this state even in non-jury cases. For this to apply, the witness has to know about material facts, have had to have a relationship with the party that would have naturally favored the party, and the witness was available to the process of the court. Now, maybe not for Miss Williford because she was out of state, although her deposition was taken, but Miss Boardwine lived in Sullivan County, so she was available to the process of the court, and it was Mr. McVeigh's client, number one, if she wanted to testify contrary to that. Number two, you would figure that if she were a defendant in this case, which she was, she would testify contrary. She never showed to testify. And as a result of that, I would think that most respectfully, insofar as Miss Boardwine is concerned, the original missing witness rule, which is applicable in non-jury cases now in Tennessee, and that's been a kind of a late phenomenon, should apply to show, well, not only Miss Boardwine, but Miss Alice Williford, but basically Miss Boardwine, who was there in Sullivan County, that if she had shown up, she would have testified exactly in the same way to her prejudice as basically that's what the court found. And I think that the court applied that. All right? In sum, I know that this is not a purely factual case. This case also travels on the Lodestar case of Rogers versus Louisville Land, which of course incorporates FDIC versus Allen, a bankruptcy court decision from this judicial district of the bankruptcy court. This court below, the Chancery Court, excuse me if I forget, but if you will look at Allen, you will look at Rogers, and you'll look at the conclusion of law, found that 8 or 9 of the 11 or 12 Allen/Rogers Louisville Land factors applied in this particular transaction, applying basically the undisputed facts. As such, it found, and I think correctly, that the corporate veil could be pierced. Miss Boardwine was a stockholder. Miss Alice Williford was a stockholder. I can concede one thing to Mr. McVeigh. Mr. Ken Williford had never been a stockholder, but he certainly was an officer of the corporation. Okay? So whether that would create any liability on him in a derivative action, I know not. But my time, I've used 9 minutes. Does the court have anything else that it wants to ask of me before I make one last comment?
I hear nothing.
Thank you, and I just want to say that this lady, Miss Lomax over here, is my favorite clerk of all time in 38 years. Don't tell my wife I love her, because if she knew that, my wife, she would hit me in the head with a meat cleaver. Thank you very much.
Well, guess what? She can come back and watch this on video if she wants.
Yes, it will be on. Yes, it's being live right now.
Yes, Your Honor, it's probably a good segue into what I did not get to in my original argument. I do want to mention a couple of things. The Rule 59 motion that I filed was because the court's first ruling required me to produce the names of all stockholders of AAA Custom, many of whom were not parties to the lawsuit. The court below was getting ready to issue judgments against people that were not parties to this lawsuit, and so I filed a Rule 59 motion to try to correct that. Technically, the judge never ruled on that motion and just issued this final order that's before the court. I do want to talk about the Rogers factors because, as I mentioned in my original argument, it's unclear who the court is applying these factors to. You know, Mr. Santori said Ms. Williford is a stockholder, Ms. Boardwine is the stockholder. Well, that's true, but they're stockholders of two different corporations, and so we have to keep that in mind. In order to find Ms. Williford liable, the court would have to pierce the corporate veil of the original AAA. In order to find Ms. Boardwine liable, the court would have to pierce the corporate veil of AAA Custom, and in the middle, find some sort of liability between the original AAA and AAA Custom. And so I want to discuss the factors. This is paragraph 7 of the conclusions of law, and I know Mr. Santori said that the court found 9 of the 11 factors present, and I'm going to go briefly and quickly through each one of these factors. The first factor, the court says defendant AAA Custom failed to collect paid-in capital. I think it's important to note that the asset purchase agreement says that AAA Custom paid $500 for the original AAA. Fact number 39 states that $500 was put in to AAA Custom. So if we have a fact that establishes that the purchase price was put in, I have a hard time understanding how the court says that that AAA Custom failed to collect paid-in capital. So I do not believe the facts support that conclusion of law. The same thing with the second factor. It says defendant AAA Custom was grossly undercapitalized. Again, if the purchase price is $500 and somebody put in $500, that seems to be the appropriate amount of capitalization based on the business that was conducted. Defendant AAA Custom failed to issue stock certificates. There is some question whether those stock certificates were issued for AAA Custom. I do not, though, think once the court looks at these other factors, that would be a determinative factor for this. Now, factor 4 says AAA Custom used the same office and business location as AAA. Well, first of all, that does not apply to Ms. Boardwine. The facts are clear and go into detail that Ms. Boardwine owned several other businesses and had offices other places. So she did not share office space with AAA Custom. That factor should not count against her, so to speak, when we're talking about piercing the corporate veil of AAA Custom. But I would also say, as it applies to the original AAA, it's a manufacturing business. I would venture to say that a large percentage of manufacturing businesses that are purchased take place in the same location as the business that was purchased. And so I do not think that should weigh heavily in this case. Factor 5, AAA Custom and AAA employ the same attorney, me. First of all, that's just untrue. I've spoken about that in my brief. There's a conflict report in the file in the record that maintains that says I do not represent the original AAA. I never filed a pleading in the court below for the original AAA, and frankly never represented them. But as it might apply to Ms. Boardwine, there is, and it's true, AAA Custom and Ms. Boardwine shared the same attorney in the court below. There's no evidence they shared the same attorney in the transaction. And I believe that's what the Rogers factors look at, is in that transaction, did they share the same? There's no proof that any attorney was used in the transaction. AAA Custom was used as a personal conduit for another individual. I want to clarify something Mr. Santori said. The personal loan that was paid, according to the facts, was a personal loan of Ms. Williford, not of Ms. Boardwine. Ms. Boardwine did not have any of her debts paid. There's no fact that alleges Ms. Boardwine had any of her debts paid. Ms. Boardwine did not have any of her debts paid. And to be clear, it's fact 44. And she says, Jim Street, who's one of the shareholders, paying Alice Williford's bank loan off. If it's a personal debt of Ms. Williford, it's not a debt of original AAA or AAA Custom or any other party here, and so that should not factor into the conclusion. I'm running short on time. Obviously, this is, I do think it's a law-dependent case. There's a Four Corners document. The court somehow found other liability. That liability is simply not supported even by the facts that the court put down. Thank you.
Court's thanks to counsel for both sides. We appreciate your briefs and your arguments today.